Good morning, everyone. I know everybody in the bookstore can hear me. So here's what we're going to do. A couple qualifiers for you. First of all, this is not the full session. And what I mean by that is, if I'm doing a full breakout, we do all sorts of things Jeopardy style. So it's been reformatted to fit within the time frame that we have today. 3 things you need to know about today. Number 1, it's Jeopardy, right? You answer in the form of a question. That's what you need to think about. Number 2, the cool part about Jeopardy is what? Bragging rights. So you want to keep track of your score because you never know. The person sitting next to you might not do as well as you. And number 3, just like Bruce said, I am all about having fun. I think you can learn and have fun at the same time. So that's exactly what we're going to do. So here's what we have. I have a category for you today that will amaze you, sort of. Here's what we do. Intentional actions, that's what we're talking about today. Now, you know how it works. This is your first question or answer, depending on how you look at it, for 100 points. Here we go. In order to receive protection under the ADA, an employee must seek some type of this. Think about it. I would play the music, but we don't have the music. Here's the answer. What is a reasonable accommodation? Now, you're probably thinking, okay, this makes sense. Well, here's the case that this comes from. It's out of Florida. Supermarket chain. Here's what happens. They have an individual who's a cashier. And miraculously, she has a few problems. Okay, she has more than a few problems with her interaction with both her coworkers as well as with customers that she's checking out. Constant complaints, write-ups, whatnot. HR calls her in and says, listen, we have a problem. We got to discipline you. We're going to put you out. You got to, sort of pay attention. And only the way this can work, right? She walks in. She opens up her pocketbook. Boom, all these drugs. By the way, I'm ADHD and I'm bipolar, and I'm really sorry, but, I won't do it again. They put her out for a couple days. They tell her, look, if it happens again, we got to get rid of you. Of course, you know what happens. They bring her back, and it happens again. They call her in, they cut her loose. After she says, well, I would just like a second chance because, I'll do better. They cut her loose. She, of course, files suit, right? That's why it's one of the questions. And then, court looks at it and says, hold it. She didn't actually ask for a reasonable accommodation. Now, mind you, we all know you don't have to use the words and whatnot, but all she asked for was a second chance to do it again. So if you don't know what the issue is as an employer, you don't have to be clairvoyant. She never asked for a reasonable accommodation, never went there at all, case dismissed. Now, if you weren't sure about that one, here comes the next one for 200 points. You know how this works. Here we go. Employees who engage in verbal altercations with co-employees and proceed to make these may be terminated despite a disability. I know you're all thinking. All right, here we go. What are threats of violence? Now, every once in a while, I get to give you a case that actually comes right from where we have a conference. So it's great to be here again at the SHRM Annual Conference in Las Vegas, and this case comes from the city of Las Vegas. So see how perfect is that? Here's what we have. An individual who works for Public Works, specifically in the sewer division. One of these guys that goes down into the sewers to make sure that they're open. They have a specific truck that they use, and he's hearing impaired. And he's claiming to the employer, the city, that, hey, the truck is actually creating an issue for my hearing. It's making it worse. So I would like a headset or some type of additional accoutrements to make my hearing not go bad as quickly. Ultimately, they give him this. And one day, he's got these big headphones on, and his colleague reaches over to him because he's trying to have a conversation about how they're doing their job. And I guess he doesn't really hear him. Shocking, he's got the headset on, takes the headset off, and apparently they get into an altercation, which of course means that HR ends up having to do an investigation. And now under the category that it cannot get better, apparently he is one of those employees that doesn't play well with others. And he has a laundry list of incidents with his co-employees. So this was sort of the last straw, as it were. So, of course, you know what happens. They cut him loose. And because he's hearing impaired, he files suit claiming disability discrimination. And the court's like, look, it's okay for you to be reasonably accommodated. It's okay to have your disability. It is not okay to threaten the lives of your coworkers, their families, your supervisors. Case dismissed. Just saying. Okay. Here we go. Now we're going for 300 points. Slowly getting more challenging. Okay? In anticipation of surgery, an employee contacting their employer to obtain benefit forms for this purpose is not equivalent to providing a request for accommodation. This is about the time of the morning where you're thinking, is the coffee working? All right, here we go. What is long-term disability? Now, before you sit there and say to yourselves, how much of this coffee did I actually drink? Here's what happens in this case. We have an individual employee who's working for a landscaping company, injures his shoulder, comes in HR, he's like, listen, I need time off to get the surgery done. They say, okay, not a problem. They give him FMLA forms, long-term disability forms. He takes them to the doctor, fills them out, sends them where they need to go. They do the surgery. Then, you know, because this happens never to any of you, I'm sure, there's a complication. It takes longer for his shoulder to heal, which takes him beyond the original time that he had told his employer he would be out. And does he inform the employer? No. So, of course, he ends up being a no-call, no-show. Employer ultimately cuts him loose. He then files suit saying, you knew that I was out, and you knew why I was out, and it was going to be a longer time. And the court says, well, wait a second. Exactly how would your employer know? Well, I got these long-term disability forms, and I filled them out and sent them in. All right, quick digression. I'm not even going to ask for hands, but let's be very honest. How many of you actually handle the long-term disability within your organizations in-house? Most people use third-party providers. One person. But most people use third-party providers. So the challenge, of course, is you don't get a whole lot of information. They may tell you who's on the rolls, but they don't generally give you information about every single person that might be on long-term disability. So the court came back and said, it's nice that you did everything for long-term disability, but you never talked to your employer. If they don't know, they can't help you. Case dismissed. Now, getting a little more challenging. 400 points. Here we go. Without bilateral cooperation, this cannot realistically take place, and the employer may not be held liable. I know, need another sip of coffee. Here we go. What is a valid interactive process? Ladies and gentlemen, this is one of those great cases where you're like, wow, I just want to be in HR. Because here's what happens. Case is actually against Coles. The individual has diabetes. And the way it apparently works at the time, their shifts vary. And it was becoming problematic for this person to deal with regulating their blood sugar. So they went in, they asked for an accommodation. There were some challenges there, and they're sitting in the meeting with HR. I'm sure none of this has ever happened to any of you. They're sitting there, they're trying to discuss what the options might be. Something gets said, the employee gets upset, stands up, says, I quit, and takes off. Now, I know what you're probably thinking. If this were me, I would sit there and say to myself, thank God, one problem done, check, move on. That's not what this HR person did. They actually followed the person out of the room. You don't really want to quit. Let's talk about what we can do. Kept on walking, left. Last thing they said to the HR person, I quit. Now, I know what you would do, but here's what this person did. They called more than once. Left messages the employee wouldn't pick up. Sent an email. Hey, let's talk about this. Nothing. So ultimately, I mean, what else are you going to do, right? They let the employee quit. Employee turns around, files suit saying, you didn't go through the interactive process. And the court turns around and says, okay, hold it. It sort of takes two to have an interactive process. Not only did they actually sit down and physically have a conversation with you, you left the room, they followed you. They called you. They emailed you. You ignored them. You don't get the benefit of anything. Case dismissed. Now, how are you doing? Do you have all 1,000 points? You know why? Because it's time for Final Jeopardy. What are you willing to wager? Remember, the people sitting next to you, who's going to end up having more points? That's really the goal here, right? I mean, if we learn something, that's great. But before you think about what you're going to wager, here is the clue of the question. Technology. Think about what you're going to wager. Here we go. Technology has created a situation today where it's possible that many job descriptions could be altered to allow for this type of work. All right. Now everybody's thinking, okay, am I going to beat my colleague sitting next to me? Here we go. What is telecommuting? Now, out of the Sixth Circuit, you've probably heard about this case. It's with Ford, with the EEOC. They've gone back and forth. Woman has severe IBS, irritable bowel. They went back and forth over whether or not she had to work physically at the work site. Skip the fact that some of her colleagues that were perfectly healthy were able to telecommute doing the exact same job multiple times. And temporarily, she was allowed to do the same thing. And the court sort of eloquently turned around and said, listen, this is simple. It's not 1920. I know you're not in the session on overtime that just came out, but this is one of those things that actually makes sense, right? I mean, technology allows us to do all sorts of things. You could certainly allow this person to remotely work. And by the way, there's nothing in your job description that requires them to physically be there. And they go through this whole other discussion over the types of jobs today that we have and how things work. Case dismissed. Now, throwing a lot of stuff at you. But really what you want to know what are the takeaways. So here we go. The kinds of things you can use back in your office. The first thing is, just like the first case we talked about, what are the actual claims? What are your people actually griping about? I mean, I don't want to sound silly, but we've all been in kindergarten and played the telephone game where you sit in a circle, and it started off as a horse, and it ends up as a cow. Same kind of deal. That's why we write stuff down, right? I mean, that's what you expect from all of us attorneys. We're going to ask you to write down everything. Particularly important in this case because the employee had never asked for reasonable accommodation, only asked for another chance. Not the same thing. Next, listen, I get it. Particularly if you're not in a huge organization, everybody tries to be nice. You want to cut somebody a break. Hey, listen, you did X, Y, Z. We don't want you to do that anymore. Do us a favor, don't do it again. And it stays up here in your head instead of written down on paper. There's a reason why a verbal warning is written down on a piece of paper and you check the box, verbal warning. That's how they got out of that case because they knew the number of times this individual had challenges with his co-employees. Now I know what you're thinking. Depending on what state you're in, I don't need to document a conversation, I can just record it. I would never tell you to do that. It never comes out the way you think. But, do you remember, I recognize we're in Las Vegas. Do you remember everything you did last night? Because, not for nothing, but ladies and gentlemen, here's the challenge. I don't remember everything I did yesterday. I certainly don't remember the last conversation I had with a client about one of their 1,500 employees. Would you? That's why I'm going to encourage you to write stuff down. Listen, anytime someone's bringing up the ADA, it's very fact-specific. That's what the courts, that's the regulations talk about. That's how we have to deal with this stuff. So writing stuff down only helps you, only protects you later if something happens. Now I have to tell you, finding that Coles case, reading about how they literally chased the woman out of the room, please don't leave. How cool is that? I'm not saying you should do that, but it's kind of cool. There are times where tenacity becomes very important. In the ADA, it is incredibly important. There's a reason why we go through these steps, why we encourage you to try and figure out what is it they need and what can we offer. And by the way, you didn't hear me say you have to do whatever they request. You have to do what's reasonable. They may not like that. That's too bad, right? But thinking through this, trying to be 5 steps ahead of your employee, that's how you succeed in the ADA. And lastly, if you haven't figured it out before, taking a look at your job descriptions and augmenting them for the kinds of things that you would find, for example, in workers' compensation or under the ADA becomes critically important. Can you do certain functions remotely? Is that a good thing? You might find that it is. I will submit to you, if you're doing a receptionist or a Walmart greeter, right, can't remotely have that. But there may be other positions that you can. Do you put things in your job descriptions like minimum ability to lift, running, jumping, what have you? All the kinds of things you would need for, thank you, pigeon chasing, who knew? All of these things, though, you want to think about now. Better to figure it out now than figure it out later. And by the way, I'm not suggesting that you download it from the government website that has 150 different things you could potentially do in a particular titled item. That never works out, right? Because you really only do 5 of those things, and that's always the problem. So sit down and take a look at it. Now's the best time to do that before you have a problem. Now, should you have any questions about any of the cases I talked about, if you want the full case information, I'm more than happy to provide that to you. Feel free to reach out. I've been tweeting the entire conference. You can certainly follow me or connect up with me on LinkedIn. I hope this has been very helpful. It's always a pleasure to be here with you at SHRM, and I hope that you have a wonderful rest of the conference. Thank you very much.